Now, the third is silence is golden. Art of knowing what not to speak and when not to speak. Nothing strengthens authority so much as silence. This is what Da Vinci said, and inspired from that, I take it forward. Three of the most essential tools that should be in every lawyer's toolbox are silence, active listening, and critical thinking. Here, let us focus on the virtue of silence. In my professional career over a period of time, I have learnt that silence is not only golden, it has its own sound. I learnt it in the court, noticing that after making the best point, which would have secured the relief for a client, a lawyer kept on arguing and ended up diluting the impact of the best point that he made. The relief eluded the lawyer. Lesson number 1 in the chapter of silence is to know when not to speak anymore and take your seat. You can know the moment by the body language of the judge, body language of the opponent, or by your own instinct. Now, these are the things which are integral part of your overall upbringing, your overall style that you practice as a lifestyle, and it doesn't come one fine morning. It has to be acquired over the years, and the instinct is something which is very natural and personal to each of you. Instinct will help you in making an assessment of when to stop. If you have prepared well, prioritized your points, and covered all relevant aspects of the matter in your submissions, if you fail to take advantage of silence, you might lose out on two critical advantages. First, you miss the opportunity to observe the valuable verbal and non-verbal leaks that silence inevitably forces your opponent to make. Second, you obliterate the ability to seize upon the risk adversity the greater majority of people possess. In order to make it easy for your instinct to help you in such situations, it is important to follow a particular sequence of submissions which makes you first present the facts in a coherent manner, state the law that applies, and conclude the submissions at a note which is your best point. I prefer to call the sequence as an inverse pyramid. See, the inverse pyramid is like this. Once you scale down to the tip of the inverse pyramid, your instinct will tell you to take your seat. So first of all, in the inverse pyramid, you lay the foundation, which is broad, and then you have to, by method of elimination and filtration, ultimately reach to the conclusion that you wish to present before the court. Equally important for the courtcraft is to know as to what will not be appreciated by the court, either as a submission or as an interjection or as an illustration or as an observation which is not called for, which is not contextual, which is not in good taste, which may be offensive to the environment of the court, or which may unnecessarily waste the time of the court. The key is to avoid creating anticlimax. Situations when silence is the way to go. When the court is inclined in your favor, it is extremely annoying for the court that the counsel, by elongating the arguments, is preventing the court from proceeding further, either to hear the opponent or to pick up the matter next in the list. Silence as a technique is equally applicable to the cross-examination. If the answer given by the witness has achieved your purpose, further cross-examination could be fatal and may amount to undoing of all the good work which you may have done till that point. Any unnecessary question on a topic which should be closed by us pursuant to the favorable answer will reopen the room for the witness to explain the inconsistency or self-damaging component of the answer given by him. It has also been seen that sometimes in a cross-examination, the counsel is giving a suggestion to the witness which is contrary to the case of the client. To illustrate the point, the plaintiff wants to establish that the defendant used its trademark in a gathering held by him at the defendant's place, conveying an impression as if the gathering is held or is sponsored by the plaintiff. And for the said purpose, it produces a witness stating that he had also attended the gathering so held by the defendant. The counsel for the defendant is not supposed to suggest to the plaintiff's witness that there were about 50 people attending the said gathering. Irrespective of whichever way the question is answered, an irretrievable damage has already occurred by a suggestion that a gathering was held by the defendant attended by about 50 people. So the purpose is defeated.